Hello, everyone, and welcome to the first webinar of our 2023 Labor, Employment, and Human Rights Series, Cover Your Bases, Navigating Equity, Diversity, and Inclusion Considerations from Inside Out. While I introduce myself and our speakers, please see the information slide that is on your screen. So my name is Nicole Singh, and I'm a Toronto-based partner in Fasken's Labor and Employment and Human Rights Practice Group. I'm joined today with a number of colleagues. First is Rachel Younan, a partner in the Labor and Employment and Human Rights Group. I'm also joined by Laura Epplett, an associate in the Labor and Employment and Human Rights Group. I'm also joined by Grace McDonell, an associate in both the Labor, Employment and Human Rights Group and Litigation and Dispute Resolution Group, and Justin Ping, an associate in our Privacy and Cybersecurity Group and a former member of our Labor and Employment and Human Rights Group. We want this presentation to be somewhat interactive today. So to that end, we have some polls built into our presentation. We will have a test poll in just a moment. To access the poll, there is a chat box next to the video screen, which has a vote button at the bottom. So when it's time to vote, please click that button, submit your vote, and then click the chat button once you're done. So let's do a little bit of a test now to see if everyone can get that working. So now, the testable question is, are you going away for the family day long weekend? So if we can get you to submit your answers. Okay. And so sadly, not very many people are going away for the family day long weekend. I did not actually submit my answer, but I fall into that category sadly as well. Oh, there's still some answers coming in. Clearly, everyone's getting the hang of it. It still seems that the overwhelming answer is no. I'm glad to see everyone's able to get that working. So let's get right into the agenda. So we're going to start off today's presentation talking about policies and procedures. And in doing so, we're going to address special programs. A lot of people have heard of these as affirmative action programs. The Canadian version of that are special programs. So we're going to cover that off. And then we'll talk about data collection and privacy considerations, followed by resources and affinity groups. We'll then switch gears and talk about education and training. And in that section, we'll talk specifically about implementing EDI policies and procedures and being reactive versus proactive and how to do that type of training. And then we'll end with responding to complaints. So we'll talk a little bit about investigations and both employment and service-based types of investigations. And then we'll finish off with some lessons from case law and how to mitigate some of the risks that EDI-related matters can pose and how to navigate some of those risks that come up as we see in the case law. So in terms of starting us off, at Fasken, we recognize that EDI is a top matter for most employers. Particularly in the last few years, we've seen an increased interest in many organizations as they started hiring their very first EDI officers and other executives to help them and their organizations navigate EDI-related matters. So employers are continuously having to grapple with many complex EDI-related issues, including things like developing a successful EDI program, recruiting and promoting diverse talent, cultivating a workplace that is inclusive, navigating tricky privacy issues related to the collection of EDI statistics, and ensuring legal compliance and avoiding legal pitfalls. So as a starting question, why does EDI matter? So if we can just actually go back to the last slide. So the starting place is, of course, creating equity among different groups of people is the right thing to do. Many of you may have attended our Black History Month event yesterday that was led by Dr. Ibram Kendi, and he touched on this concept. And he talked about creating equity benefits everyone, not just the subjects of certain EDI initiatives. And this slide that we have up here really includes stats that support that idea, that creating equity benefits everyone. So an equitable, diverse, and inclusive workplace attracts top talent, it drives innovation, and it increases profits. So the very first bullet there, it says gender diverse leadership teams are 21% more likely to outperform. Racially and ethically diverse companies are 35% more likely to perform better financially. Diverse companies are 70% more likely to capture new markets and customers. Companies with equal men and women are earning 41% more revenue. 87% of the most admired companies see a positive impact of diversity and inclusion on their business performance. Inclusive companies are 1.7 times more innovative. So these stats sound great. And the question is really, well, how do you get there? How do you get to a diverse workforce that reaps these types of benefits that we're seeing on these slides? So to get there, if we could just advance to the next slide, there's some key concepts that as an organization, individuals need to be aware of so that you can successfully implement various EDI initiatives. Now, what we have on the slide here are just 3 concepts that we're going to touch upon. They are by no means an exhaustive list of the things that you should keep an eye out for, but they are 3 things that we thought we would touch on for the purposes of today's presentation. So the first one being bias. So bias can show up in a couple of ways. It can show up as explicit bias, and it can also show up as implicit. Explicit bias is a result of conscious and deliberate thought. Implicit bias, by contrast, may result from past experiences, expectations, or stereotypes that form an opinion in your mind that you are unaware of. So it's involuntary and unconscious. So in some respects, it's actually more problematic because you're not even aware that you have it. So just to unpack unconscious bias a little bit more, it's implicit attitudes or motivation. It's not deliberate, it's unintentional. And again, people often don't realize they're making unfair assumptions or stereotypes. It can show up in the form of gender bias, age bias, bias against certain ethnicities or cultures. And it can also take the form of affinity bias, beauty bias, perception bias, confirmation bias, halo hornet effect. I won't go through each of those types of biases, but one I will is confirmation bias. So that's really the tendency to process information by looking or interpreting information that is consistent with existing beliefs that you have. So an example of that is if you believe that certain racialized groups are lazy or less intelligent than other groups, this may impact the way or will impact the way you assess people from that group. So you start looking for evidence that confirms or supports the beliefs that you have. So how can this manifest in the workplace? Well, in recruitment or promotions, for example, you may unintentionally look for negative information that confirms your beliefs about that person or group of people, rather than looking for positive information that contradicts your beliefs about that person or group of people. Racial profiling, the second term on the slide there, what it means is differential treatment or scrutiny of an individual or group of people because of negative stereotypes related to their race. So it's actually not specifically recognized by human rights legislation, but it often manifests in the form of discrimination, which of course is covered by human rights legislation. Racial profiling can manifest in different ways. It can come up through statements, signs, symbols, applications, or employment practices. And then finally, microaggressions is the third term on the slide there that we wanted to address. So microaggressions involve a behavior communication. It can be spoken or unspoken that feeds into stereotypes. So it can be intentional or unintentional and demonstrating unconscious bias or stereotyping. And it can be experienced in a variety of ways. It can be experienced as racism, sexism, ageism, or ableism, just to name a few examples. And for the subject of microaggression, it can make them feel like the workplace is uncomfortable, unsafe, and toxic. So a key thing to keep in mind with microaggressions is that people are often unaware that they've engaged in a microaggression. So they're unaware that they've made an offensive or demeaning comment or have acted in an offensive or demeaning way. Microaggressions are often subtle, and so sometimes the person who's even receiving the microaggression might not even be aware of it. They might feel uncomfortable, but may not know exactly why. So there's lots of different examples of microaggressions. Just a couple of examples. As a lot of organizations are starting to develop special programs for recruitment practices, so hiring different diverse types of individuals, asking somebody, for example, if they were hired as part of a quota or an affirmative action or a special program, that can very well be interpreted as a microaggression. Now, I should say that context, of course, is always important. And in order to understand whether something's a microaggression, the context is always very important. Another example, and actually this comes up quite often in law, is the idea that a woman, for example, is the more junior person or has a less senior role. So for example, a man and a woman, both working at the same law firm, show up to a client meeting and in a boardroom, for example, and the man is assumed to be the partner or the lawyer on the file, whereas a female is assumed to be maybe support staff or a more junior role. So if you were to approach these two individuals with that assumption, that the female in that example could view your assumption as a microaggression. So those are just a couple of examples. And of course, again, context is key. This does not cover every situation, but that's just a couple of examples. So if we can move to the next slide, we're going to talk a little bit now about special programs. So one of the most tangible ways that employers often feel they can create a more diverse workplace is through creating special programs. So in the last few years, I personally, and I'm sure a lot of my colleagues feel similarly, have gotten a lot more questions from clients about special programs. How do you develop them? How do you implement them? Will we receive complaints from people who are not covered by them? All sorts of questions. So the key thing that I always say to clients that ask me about special programs is you really need to understand the purpose of special programs and what the statute says is a permissible special program before you start implementing or developing one. So what exactly is a special program? So a special program is any program adopted by an employer or other service provider that aims to improve the conditions for an individual or group that has faced disadvantage. So again, like I said at the start of the presentation, you've likely heard of affirmative action programs. That's a common term that's used in the States, and it's notwithstanding the fact that we don't live in the States, that's commonly how they are referred to, but here in Canada, they are called special programs. So they are recognized formally in human rights legislation across Canada. So in all of the jurisdictions, they are recognized across the country. We'll provide some examples of what a special program might look like and provide you with some guidance on things to think about when developing a special program. But briefly, it's helpful to understand the aims and context of special programs. So special programs and their recognition under human rights legislation really goes to acknowledging that there is a difference between the concept of equity and equality. So special programs are designed or intended to achieve equity. So I'm going to pause here and really unpack what is the difference between those two concepts, equity and equality. So they're commonly conflated or used interchangeably, but they are different. So understanding the difference is key in developing a special program. So formal equality is when each individual or group of people is given the same resources or opportunities. Equity, by contrast, is also called substantive equality, but it recognizes that each person has a different circumstance and therefore allocates resources and opportunities differently to each of those individuals to arrive at an equal outcome. So if we take a very simple example, but I find it a visually helpful one to illustrate the point, if we can just advance to the next slide. So in this very simple example, what we see here is on the left side, equality, and on the right side, equity. So on the left side, each of these individuals is treated equally. They're all given the same tool or same, in this case, the boxes that they're standing on, they're given the same tools to gain access to viewing the baseball game. But as you can see here, when they're treated equally, 2 of the 3 are able to view the game, while 1 is not able to. Equity on the right side, all 3 of them are able to watch the game, but they've been given different tools. One of them, the man that's standing there, is of course tall. He doesn't need the tools that the other 2 need, so he's not given it, but he can still access the baseball game. The middle person requires 1 so that they can see the game, and the third person has 2 boxes so they can see it. So in this, it's a very simple concept, but I think this helps to really illustrate it, that the difference between equality is really you're treating everyone the same in the left example, but it doesn't actually result in equity, being that they can't all see the game. On the right side, equity doesn't mean you treat people equally. In this case, not all of them are given the same tools, but all of them get an equitable outcome, being that they can all watch the game. So again, special programs are intended to help level the playing field, just like the photo we just looked at. Now, typically, as we know, an organization is prohibited from treating people unfairly. So, and on the basis of protected grounds, of course. So, for example, you're generally prohibited from treating men and women differently at work. So a question that often arises when I'm giving advice on special programs is, how can we create programs that create distinctions? Isn't that against the Human Rights Code or human rights legislation? Well, special programs recognize that certain groups are historically disadvantaged. They allow for the different treatment of disadvantaged groups to help correct that historical disadvantage. So, for example, in various industries, women are underrepresented in comparison to men. So a special program that benefits women in such an industry and tries to remove barriers faced by women in the workplace would in fact result in men and women being treated differently, but all, of course, with the goal of achieving equity or an equal outcome. So the purpose of special programs and the implementation of them is really twofold. So the first is that, and most importantly, it's implemented to address real disadvantage for a specific group or group of people. So it's a tool that you can implement as part of your overall EDI strategy. And again, it's to address real disadvantages and help correct those disadvantages. And the second purpose of a special program is really to protect your organization. So to ensure that you have protection in the event that anyone attacks or feels that the special program is discriminatory, and so they feel that the special program is inappropriate. When you have a carefully thought through special program, you really are protecting the organization from attack from people who are not covered by the special program. So as you can see on this slide, it goes across all the different jurisdictions and whether or not that jurisdiction has a special program, as you can see, all do. And then the acts of their human rights legislation that deal with special programs. And then the last column there is whether pre-approval is available. So in most, or in a lot of instances, pre-approval is available, but not necessarily necessary. That you must get pre-approval. So generally, you don't need to obtain pre-approval, and most organizations do not actually go through the process of obtaining pre-approval. Instead, if the special program that they have is thoughtfully developed and designed in a manner that's consistent with the legislation and available guidance, and there is a lot of good guidance from human rights commissions, then it's possible to create the special program that complies with best practices and, of course, legislative requirements. And most organizations rely on that rather than seeking pre-approval. In Ontario specifically, it's not discriminatory to put in place a program if it's designed to relieve hardship or economic disadvantage, if it's designed to help disadvantaged people or groups achieve or try to achieve equal opportunity, or if it helps eliminate discrimination. In Ontario, a special program has to satisfy at least one of those 3 objectives in order to be considered a special program. So similar to EDI policies, which my colleagues will address later on in this presentation, good plans should be developed through consultation to identify several things. So the first being the rationale, supporting data, eligibility criteria, and evaluation methods. I'll talk a little bit about each of those. And it's also important when developing a special program that there is some level of consultation. And so that can include individuals and groups targeted by the program. So if you're going to be implementing a program designed to help Indigenous peoples, for example, you may want to consult with those individuals or those groups to understand how can this special program possibly help this group of people. You can consult with labor unions or employee associations. Those are just a few examples. So what does consultation really mean? Well, it can really help you identify the specific types of barriers that the special program is designed to improve. So most importantly, consultation is important because you are actually consulting with the people who are impacted versus assuming what you feel would be best without their input. So consultation can be a very helpful tool when designing a special program. Now, in terms of the rationale, that is simply the reason the program is being created. A good rationale should always identify who will benefit from the program. It should provide reasons why the target audience is considered to be experiencing hardship, economic disadvantage, inequality, or discrimination. And it should always be evidence-based. So objective evidence, not subjective, not your personal impressions, but objective evidence that supports the need for the special program that you're looking to implement. There has to be a real problem that you're trying to solve. And so how do you do this? How do you get the evidence you need to support the special program? Well, it can be achieved in a number of ways. It can be achieved through statistics in the industry in which you operate. It can be achieved through gathering data within your organization. In terms of pulling the stats, that's something that my colleague Justin will be addressing later on. There are a lot of privacy considerations that you have to take into account before gathering that data. Now, the rationale should also explain how and why the program would help relieve the hardship, economic disadvantage, inequality, or discrimination of that particular group. And then it should also outline the expected time period for the program. So is your program going to be 1 year, 5 years? What's the length of the program? And it should be realistic. So not just a lofty idea, but a realistic time period that will hold you accountable to arriving at the goals you're setting out for this special program. And ultimately, carefully thinking through the rationale makes it easier to develop the eligibility criteria. It helps you to evaluate the program once it's developed. And a clear rationale also makes the program easier to understand for people not only using it, but also people who are not covered by it, to help them understand why they're not covered by it. Okay, so just to advance to the next slide. So the eligibility criteria. So special programs must have eligibility criteria that only relates to the purpose of the program, and they cannot discriminate based on other grounds in the code. So very narrow criteria severely limits who can participate in the program. And this might actually defeat the rationale behind the program by excluding people it was meant to actually help. So on the one hand, if it's too narrow, then you might be excluding people. But on the other hand, criteria that's too broad might result in providing benefits to people who don't need them. So for example, if you came across a study that shows that Black females are underrepresented in your specific industry, eligibility criteria that's too broad might be that the company implements a program for preferential hiring for all women. So if the industry does not show underrepresentation of all women, then you now have a preferential hiring practice that's too broad. On the flip side, an eligibility criteria that's too narrow might be preferential hiring of Black females from a specific country or specific background. So it might be too narrow and you're actually missing some of the intended individuals that you were hoping would benefit from the special program. Also including different types of, so if in the same example there, if you also included within the preferential hiring of Black females, only those under age 50, for example, that could result in age discrimination. So you have to, again, make sure that your eligibility criteria is in line with the evidence that you gathered, it's solving a real problem, and that it doesn't actually inadvertently create discrimination through the criteria you're using. So on the evaluation of the special program, you should be monitoring it. And that's important to really just help ensure that it's effective. So is a special program actually achieving what you set out as an organization for it to achieve? Evaluating the program also helps you identify opportunities to improve and grow. So if the program is in place, but you're not actually seeing any real growth in the group, for example, that you're trying to increase representation of in your organization, then perhaps you need to revisit the program and adjust various elements of it to ensure that you're actually achieving your targets. It really helps facilitate accountability within the organization. So if you've set a 5-year mark and at the end of that 5 years, you don't actually see any progress, then it's holding the organization accountable. And again, you'd have to think through whether changes need to be made and why are you not hitting the goals that you had set out to hit. And then really communicating the program results to the organization and clients, things like that can be very helpful, again, for accountability and transparency. So having employees evaluate the program, right? So did you actually achieve the goals that you set out to? That allows the employees within your organization to also hold you accountable. Now, when you're dealing with special programs, it's most important to look at qualitative versus quantitative data. So you should look beyond just the numbers, for example. So you may see that you are doing better in hiring certain groups, but they are moving up. But are they moving up within the organization? So a lot of organizations are seeing this where they've put in a lot of effort to recruit certain types of people. And so you're seeing that there are, good numbers of representation at the earlier stages or early on in the recruitment, but are those individuals actually being promoted and moved up to higher positions within the organization? So if not, then you're probably not achieving the intended goal of the special program. So it's very important to look beyond just the hard data and look at what does the data tell you. So with that, I'm going to pass it over to my colleague, Justin, to talk about privacy considerations.
All right. Thanks very much, Nicole. That was a fantastic discussion of special programs, and I'm very pleased to be continuing the discussion on data privacy considerations in the EDI context. And since we're talking about data privacy, I'd just like to start off with a quick poll. So if we can just go to that slide. And on this slide, you'll see that we have 3 responses for the question, do you have a policy for employee privacy? So I'll just give 15 seconds for people to answer that poll. And as you're going through those options, you're probably seeing the distinction that I'm carving out here, which is to say that you can have a privacy policy that addresses consumer privacy. So, any personal information you collect on your consumers, your customers, but also personal information that you collect on your employees. So these can be 2 separate policies. They can also be one and the same. And right now, not seeing a lot of responses. I guess some people might not have a clear sense. And this is also a common issue. Sometimes the privacy policy, even though it exists, is buried deep within the organization's library of policies, is not necessarily well understood or well enforced or well promoted. And so while there is something on paper, it may not be followed in practice. I see one enthusiastic response to number A, so it looks like there's at least one person out there whose workplace does have an employee privacy policy. That's fantastic. All right, so looks like there might be some gaps here in terms of what might be required or what might be a best practice and what some workplaces actually have in their policy bank. And that's good to know. And that's a key consideration for the next few slides. So if we can just go to the next slide and start to unpack the consideration when it comes to how data privacy factors into EDI, the promotion of EDI in the workplace, and any special programs that you might want to establish. So, particularly if you're provincially regulated, private sector employer, and you don't necessarily have employees in provinces where there are employee privacy laws, you may not have any kind of policy that addresses employee privacy. And to be fair, that's probably because you didn't see a need to, because it's not legally required. But when it comes to EDI and EDI programs, there is actually a good case to have a policy that does address the data privacy concerns, at least in that very specific context. It's good for transparency, it's good for trust, and as I'll discuss, it's good for the best practices that we see in Canadian privacy laws, even when it doesn't necessarily apply to your workplace. So just at a very high level, Canada has a patchwork of privacy laws. Not every province has a set of privacy laws that apply to employees. Specifically, we're looking at only British Columbia, Alberta, and Quebec that actually have privacy laws that specifically cover employee personal information. If you're a federally regulated undertaking, then you're subject to federal privacy law, otherwise known as PIPEDA. And so again, you are subject to privacy laws that cover employee personal information. In most other contexts, such as in Ontario, for instance, if you're provincially regulated private sector, you're not really subject to any privacy laws, but that's not to say that you shouldn't necessarily follow best practices that we see in Canadian privacy laws. And that's because of a number of reasons. So, for example, you might have operations in other provinces where you are subject to privacy laws, and you may want to have a national approach, right? So one policy that applies to your entire workforce, both in Ontario and Quebec and British Columbia and Alberta, because it might be seen as administratively simpler. You might also want to apply a national approach that adopts best practices because it helps to minimize concerns and complaints that your employees might have about data privacy. So what the law actually requires is not necessarily what might be the best practice for your workplace. And that's why it's important to consider what are the best practices in Canadian privacy laws. How might they apply to your workplace? And particularly for this discussion, how are they relevant to EDI and to special programs? So what the slide covers off are a few considerations when it comes to the collection of EDI data. And the collection of EDI data is essentially subject to two main legal frameworks. The first of those is privacy legislation. The second, which my colleagues will cover off in more detail later, is human rights. So I'm going to focus more on privacy legislation framework. And what I've set out in this slide are four main best practices that we see coming out of privacy law. So the first of those is informed notice and consent. What does that mean? Essentially means that employees and applicants should generally know what personal information is being collected, used, and disclosed, and for what purposes. And sorry, could we actually jump back to the previous slide? Thank you. So informed notice and consent, giving employees and applicants transparency in terms of what data do you collect, how do you use it, who do you disclose it to, and for what purposes. So for EDI programs, that means making it clear to employees, to applicants that you're collecting certain EDI information from them, and you intend to use it, for example, in a special program. And that could be something that's covered off in a privacy notice or privacy policy. It could be covered off in a consent form. A lot of how this information is presented really depends on your workplace, depends on what province we're talking about. But that's the general idea, is that you give your employees and your applicants informed notice, and to the extent that it's appropriate or perhaps even required, you obtain their consent to collect that kind of information. A second key best practice is that this data collection is voluntary, and this is a pretty critical consideration. So there's certain limited circumstances where data collection is actually mandatory. Specifically, if you're a federally regulated employer and you're subject to the Employment Equity Act, you actually do have statutory data collection obligations. But in most cases, the collection of EDI information should be a voluntary exercise. And another way of presenting that is there shouldn't be any negative consequences associated with any given individual choosing not to submit EDI information in relation to an EDI program. It's important to make it voluntary because there are a lot of liability concerns when it comes to making that kind of information collection mandatory. You run the risk of violating privacy laws depending on how your program is designed. There are concerns when it comes to human rights laws, as my colleagues will discuss. And so for the most part, it's important that any EDI data you do collect is done on a voluntary basis. A third best practice I've highlighted here is that data collection should be for a permitted purpose. And just to expand on that, what I mean is the purpose should be lawful, it should be reasonable, and it should be appropriate. So for example, as Nicole covered in great detail, the collection of EDI data should be pursuant to a special program. So a program that's well designed, that's documented, that follows certain parameters, that has policies built in, people are trained on it. So the purpose is clear. And when employees submit their EDI data, or when applicants submit their EDI data, they know what data is being collected and they know why it's being collected, how it's going to be used, in what circumstances it will be disclosed. And so that's a very important consideration. Fourth best practice, just on that point, is obligations regarding the collection, use, protection, and disclosure of EDI data. And this applies more to provinces where you do have employee privacy laws. So you actually do have prescribed obligations. And just a quick note that it's important to be mindful of that. It's important to know when an employee is based in a province where there are actually statutory obligations that apply to how their data is handled. So just something to be mindful of. And if we can just go to the next slide. So this slide highlights some broader best practices that we also see in privacy laws, and also kind of ties in with, what are the main risks that we see when it comes to the collection of EDI data. So first of these best practices is anonymization and aggregation. And the principle here is that when data is properly anonymized and aggregated, it's no longer personal information. And if it's not personal information, then it's not regulated by privacy laws. And that's very important, because if it's not regulated by privacy laws, it's not subject to those statutory obligations, like when it comes to retention and destruction of the data. There's a lot of considerations there when you have personal information and you have privacy law obligations. If you can anonymize it, if you can aggregate it, you take it out of that regime, and it gives you a lot more discretion when it comes to how that information can be handled. But a key thing to note here is that anonymization is a high bar, and to be truly anonymous, the data cannot be linked back to an identifiable individual, whether on its own or together with other data. So it's important to give full consideration to what you're going to do with your data in terms of, if you do anonymize it, how are you going to anonymize it, and to what standard, so that you take it out of privacy law regulations and give yourself more discretion in terms of how you can use it, whether for a special program or whether for partnership or publicity purposes. Anonymity is also important for other reasons as well, particularly for sensitive EI data, such as information related to someone's sexual orientation. It's important from a trust perspective that you provide anonymity at the front end so you can encourage the submission of EDI data. And of course, when you anonymize data, it really does help minimize liability risks that you might face, such as by providing a defense against a discrimination claim based on a protected human rights ground. The second of these best practices, data minimization, comes out of the principle that you shouldn't collect more data than you actually need for the purpose of that collection. So in other words, you should generally limit the collection of EDI data to what is actually essential for the policy. I've helped with privacy reviews of EDI surveys, and I've seen incredibly granular surveys where there's 30 questions and they really dive deep into people's attributes and their personal characteristics, to the point where it becomes a pretty invasive exercise. And, on a practical level, it can deter people from answering these surveys because they feel like there's too much information being collected. But also, when you get that granular, it runs a risk of someone being more identifiable. And again, it goes back to the concern of, if your information is no longer anonymized, if it's personal, then you have more obligations and higher expectations around that data. So in general, it's important to minimize the data you collect. Obviously, collect what's appropriate for your program, but there's a balance there that needs to be struck and that needs to be carefully thought about. Third best practice on this slide, data protection. This one's pretty straightforward. You should protect personal information you collect with safeguards that are appropriate to the sensitivity of the data and the circumstances. So making sure that's only accessible on a need-to-know basis. restricting access generally, encrypting it, ensuring there's robust password protocols. And so that's more of a technical exercise than anything. Fourth and finally, transparency. And so I kind of discussed this a bit earlier, but again, providing notice to employees and your job applicants regarding what information is being collected, how it's going to be collected, used, and disclosed, who's going to have access to it. So just giving individuals that transparency, whether it's through policies or through notices, so they understand how their data is going to be used. And I just want to wrap up this discussion by jumping to the next slide, which highlights some common scenarios where data privacy issues arise. And as you'll see, all of these scenarios relate to how data is accessed and shared. And so the only thing I really want to highlight here is that when you're determining how data is shared, how it's accessed, it's important to understand what data you have and in what form you have it in. So if you're sharing data internally and it's identifiable and it's raw data, again, it should be confidential, it should be kept on a need-to-know basis, and that should be carefully defined in your policies. When it comes to sharing data more broadly with other employees, with third-party stakeholders, with the board of directors, it's better that the information is anonymized, again, and aggregated so that it's not personal information and you have more discretion when it comes to sharing it. But again, be mindful that to anonymize your information, it really does need to meet a high bar so that it's no longer relating to an identifiable individual. So that, in a nutshell, are the key data privacy considerations and best practices to consider when it comes to establishing a special program and collecting EDI data. And with that, I'm going to turn things over to Grace to talk more about policies and procedures.
Great. Thank you so much, Justin. As Nicole noted, my name is Grace McDonell, and my pronouns are she and her. I'm going to be jumping into policies and procedures, and I'm sure you've noticed the trend. We're going to start off with a poll. So I'm gonna read out the options in case for those who are visually impaired. So first, do you currently have EDI policies or procedures in your workplace? So we have several EDI policies and procedures. We are in the process of reviewing our current policies with an EDI lens to assess our need for additional policies. We are discussing the need for EDI policies, or we have not yet explored EDI policies at this time. I think this question, as I give you a bit of time to answer it, just showcases the spread of where we all might be at. We're all at different parts of our journey. We're all learning about these topics, as we can tell from the big agenda today. So it's good to kind of understand where you're at. Internally and the work that we do, we have between 20 and 30 policies that are EDI related. So I see a number of answers coming in about we're in the process of reviewing our current policies with an EDI lens. So in the midst of creation of policies, it's also quite important to go back into your policies that you currently have in place, as well as your precedents. We'll talk about that a little bit in terms of gender inclusive language and so on. Of looking at those policies with an EDI lens, of looking at what's already out there in terms of precedents. For example, your letter precedents. Do your letter precedents start with "Dear Mesdames or Messieurs"? That is not gender inclusive language. That would exclude someone who's genderqueer, non-binary, as well. So we want to be thinking about these things at play, and hopefully the goal today is to try to give you some of these pieces of information. So I see everyone who has answered is in the process of reviewing their current policies. So let's go to the next slide and we can start to jump in on this. So EDI policies, advantages, define the approach and move forward on a consistent application. I know both Justin and Nicole have already spoken to you in terms of having that basis of knowing where you want to go and making it a data-driven and pragmatic approach. So policies can help reinforce that and further those objectives. And then, of course, in everything has to be a balancing in terms of the risks is over-promising or collecting information, as Justin was saying, and Nicole as well, in terms of without having a purpose, without having a link for why you're asking for this information. Because as we'll go through in the policies as well as in the case law, collecting this sensitive information is very key, it's very important, but it creates a vulnerability as well, right? Especially for that anonymization aspect. So when you're reviewing your policies, we kind of throw around the term here in terms of an EDI audit. So whether you're doing that internally on your own or with the assistance of us, we'll talk about a couple lenses to be looking at these concepts. Next slide, please. So in terms of just tossing up on the screen some sample EDI policy language, obviously you want to have your objectives, and most often we see that in terms of especially on the over-promising point, is just establishing a commitment, an effort, a putting in best efforts to rise up that level of equity, as Nicole showed that picture that I think we're all familiar with in terms of who can see the baseball game or who can be a part of the baseball game. So I'll just give you a moment to read that language. Often it looks like the employer promotes equity throughout the company, and in creating those definitions. That's something as well that's really important to include in your policies, is definitions, as well as in your EDI related surveys as well. Next slide, please. This is just further sample EDI policy language. So in kind of following through on that commitment, the employer is committed to ensure that all employees are treated fairly and without discrimination in the workplace. These principles ensure that all people have a fair chance at being employed and at progressing through the organization, hiring and progression decisions being based entirely on an individual's abilities, skills, and potential. And the second policy being on the accommodation front. And one just key interesting fact here in terms of, I know that list includes visible minorities. In the next year and a half, the federal government is actually seeking input from anyone on whether or not the concept or the term visible minorities is completely accurate. We hear concepts of people who are passing, or those who should we be limiting to visible, and who's determining what's visible and not. And you can kind of get into a couple issues there as well in terms of human rights concerns. So if anyone is interested, you can Google federal government looking at the term visible minority and provide your input as to whether or not that's the correct term that we should all be using. It kind of goes into being over-inclusive or even excluding, right? So one of the main questions we often get is, okay, who does this encompass? What does inclusion actually mean? I always say it's better to be over-inclusive on who you think. It's not necessarily a picking and choosing type situation of who we're going to be lifting up here. But these are just key concepts to keep in the back of our minds. We go to the next slide, please. So as I mentioned, we have a number of EDI related policies, and we'll just go through a couple today. The first one being the harassment and anti-discrimination, bullying, and uncivil conduct policy. So I won't get into this too deeply, as I know that my colleagues Rachel and Laura are going to be discussing it, but these policies would include procedures for investigations, and much of these policies include bring a real aspect to a trauma-informed approach and a trauma-informed lens as well. Moving on to a pronoun policy. Pronoun policies can encompass a number of things to be gender inclusive in the workplace. It might look like being able to provide options to employees, for example, putting their pronouns on their door places or their name tags, putting pronouns on their signature blocks. I often get asked, if my pronouns are obvious, and I always say, are they, or is it just a sign of allyship in including your pronouns, when the burden should not simply be on those who may not have historically traditional pronouns to do that work for them. So it can also include having pronouns on your business cards, as well as having gender inclusive language in your precedents as well. So not using she and he, including they, also recognizing that there's a number of neo pronouns as well, like zir and zire. The list is ever expanding, so it's best to be inclusive on that front. And I know a lot of us here at Fasken, we focus on reviewing contracts, employment contracts with a gender inclusive lens to determine, do we need to gender this person? Can we use, their last name? And that includes correct forms of address, such as Mr., Miss, and Mix as well. So always good to confirm, to reach out and say, my pronouns are she and her. What are your pronouns? While also recognizing, often people use the word preferred, and the more appropriate term is correct. It's not necessarily a preference, but it is how you identify. It is your correct identity. The next policy being the gender inclusive dress code policy. So I think historically, from gender expression, which is now, of course, a protected ground in human rights legislation across Canada, people can express their genders in a number of ways that might not necessarily be women wearing skirts or only men wearing ties, as I wear a tie today. So we want to make sure that we're not excluding others. I remember in law school, they asked us to separate into groups, into the women's professional dress session and the men's professional dress session. And I didn't know which one to go to. So just having these lenses in your mind of, is this maybe something we can do all together? Is this maybe something that is necessary at all in our workplace? Would this make someone feel uncomfortable? Are we being inclusive? So it's always good to try to keep that gender neutral language, such as, the employee may wear XYZ being the most appropriate attire in the workplace, instead of, types of expectations for who might be wearing what. Accessible workplace policy, you might have AOTA requirements that should be factored in as well. But it should always be a broad, inclusive aspect into seeing, who can attend at work and what are the issues. Do you have gender neutral washrooms? Do you have accessible locations, especially if you're in areas holding meetings? Are those places accessible? Do you have offsites? Are those places accessible? Do you need to consider accommodations as well? And then parental leave policy, we want to once again avoid gendered terms. We want to once again recognize that a number of people can get pregnant, and not gendering those terms. A number of people can have a child in a variety of different ways. So just to be clear about that language, but not in an exclusive way. Next slide, please. More policies. Gender affirming care policy. So I often see this called as a transition or transitioning policy. And this is the preferred language, or the correct language, I should say, more appropriate language. Often when we think about the concept of transitioning, it's more of a coming home to your actual identity. So we call it a gender affirming. You're affirming your gender instead of transitioning into a totally different gender, a totally different sex. So the more appropriate term is gender affirming care policy. So if someone is taking gender affirming steps, then they will need supports likely. So what supports would be available to them? And that's what that policy would include. I always try to not and encourage all clients to avoid, saying, if you take these steps, then you're X. If you take those steps, then you're Y. And in using the term gender affirming steps, it also legitimizes that person's experience wherever they're at in their journey. And not everyone who is trans or non-binary or genderqueer is on the same journey at all. So to keep that in mind. And then employee resource group policies. I see it's on here twice. It's very important. This is important to create safe spaces at work. So for example, we have the Pride Network here at Fasken. So a employee resource group policy just permits the association of a number of your employees, whether it's, staff, anyone, to meet and confer and to create a space where you feel comfortable and confident with your employees, and to harbor good interactions. Often I find that these resource groups or affinity groups have an educational component. So they'll put on little mini training sessions just in sharing their identities and sharing their experiences. And it can have a tremendously positive impact. I think a lot of my colleagues, we often get asked, how do you get buy-in? on EDI. And I think employee resource groups are really important. And you don't even necessarily have to identify from that group, but to just say, hey, there's this space, there's this opportunity for gathering and for some type of homecoming. A work from home policy. I know most of us are kind of associating this with COVID now, but there can be a number of reasons why an employee would want to work from home based off of any experiences that they've had. So to just keep in mind, any barriers that employee may have from coming into the office or why they would potentially prefer to work from home, within a number of factors at play being, what is your workplace? Diverse hiring policy. So this kind of fits in as well with what Nicole was speaking about on special projects. So you can have a policy in place. We want diverse hiring, we want diverse recruitment. So it would essentially basically outline all of the steps for an employer to take. And then a mentorship policy as well. We talk about in different aspects of an EDI audit, right? We talk about recruitment. We talk about the interview process. We talk about EDI in the onboarding process. And then we talk about EDI in terms of the success of your employees. But we also think it's very important to have a mentorship policy to be inclusive to all and to support others. And just move quickly to the next slide. So resources, a lot of these go hand in hand with the policies, and Laura's going to talk about this too, in terms of having resources that back up your policy. So it would include gender inclusive language guides, pronoun resource guides, 2S LGBTQIA competency, land acknowledgements, microaggressions in the workplace, and safe spaces guides. So it's just having that little bit extra of the educational component to supplement the policy. And then next slide. Affinity groups. So this kind of goes hand in hand with the employee resource policy section in terms of having a safe space for all employees to gather and create community, which is always key to have allies. Allies are incredibly important. So, don't self-select yourself out because you're not from a historically disadvantaged group. You are just as important and need to be included in discussions as well to support. I believe I'm going to pass this on to my colleague, Laura.
Thanks, Grace. So as Nicole mentioned, my name is Laura Epplett and my pronouns are she, her. So let's talk about education and training. So before introducing EDI policies in your workplace or reviewing existing policies with an EDI lens, it's important to understand the legal landscape of EDI and your legal obligations in the space. So laying the appropriate groundwork by ensuring key individuals have the appropriate knowledge of the law, or you have the appropriate resources to reach out to in order to give you and guide you through this process. So for example, where do you start when it comes to to data collection? Justin laid the groundwork there, and we have some great resources that we can assist with when it comes to crafting your own approach. Secondly, is your workplace subject to the Employment Equity Act? If you're a federally regulated employer with more than or at least 100 employees, you are required to engage in proactive employment practices to increase the representation of 4 designated groups, being women, people with disabilities, Indigenous people, and visible minorities. Employers often use a self-declaration form to gather information on its workforce, which is done, as Justin said, on an anonymous and self-disclosure basis and isn't mandatory. In addition to these groups designated under the Employment Equity Act, employees may identify with other underrepresented groups. And for that reason, these self-declarations forms often expand on the terms used and encourage employees to identify in the best way that suits them. Employers must also ensure that they are reviewing their employment equity plan regularly and making revisions to ensure that there is progress. Also, are you using your diversity surveys to inform your company policy? And is your company policy truly reflective and responsive to your workforce. Diversity strategies are meant to inform an organization's EDI strategy and to assess the need for new diversity initiatives and identify trends so that the organization can focus its action plans to increase candidate representation among underrepresented groups. So if we look at the next slide, when it comes to appropriate training, there are several topics that are top of mind within the realm of EDI. So my colleague Nicole spoke to you earlier about unconscious bias, about microaggressions in the workplace, and she also spoke to you about racial profiling. 2S LGBTQIA+ competency. In this realm, it's important to have an understanding of the key terminology. My colleague Grace mentioned the importance of using gender neutral terms in language, policies, etc. An example, when addressing letters, if you're addressing a letter to an employee, you can say, "Dear Grace," "Dear Laura." If I'm writing to counsel, I can say, "Dear counsel." Don't have to assume the pronouns. Again, we want to make sure we are creating space for intersectionality. And in the realm of trans competency, given there are safety concerns that someone might be experiencing, organizations must be mindful of how they are addressing these safety concerns. Does your organization also understand the erasure of queer culture and identities, especially in the workplace? And then moving to land acknowledgements, it's essential that land acknowledgements be meaningful. So when preparing one, you are doing research on the collective history and sending a message of equity and creating a safe space for members of Indigenous communities. They are intended to show respect and reverence for Indigenous people and to recognize the relationship and tie to the land. Now, in terms of racial profiling, what does that mean and how does that manifest in the workplace? Well, for example, are we scrutinizing the work of a racialized individual because we believe that they are less capable? And this will come up actually in some of the decisions we will discuss later. And the right, as Nicole mentioned, the right to be free from racial profiling, though not specifically recognized by human rights acts, often results in discriminations. So why should you care? Making sure that you are able to understand what it is that you observe in the workplace will help you to take action to stop it, or else there could be potential liability, which we will highlight later in the cases. So I'm going to turn it over to Rachel now, who's going to talk about reactive versus proactive steps.
Thanks, Laura. So we'll start with a quick poll for the audience today. And we'll ask you, have you introduced EDI training in your workplace? Some of you, as Grace, I believe, said at the outset, that you may be at varying stages in your journey on EDI and EDI considerations in your workplace. So I've seen some results come in saying, no, you haven't yet introduced that EDI training. Some are in the process. And a good share of you joining us today are well underway and have introduced EDI training. So that's fantastic. And again, everyone's at a different stage. And so there's always opportunity for everyone in the EDI space. So let's talk about why you might want to implement training. And I think here we go back to the reality that this project of equity, diversity, and inclusion is one that requires a proactive strategy. It is, unfortunately, the reality just is that there are no quick fixes here. And so effective EDI strategy, planning, and implementation takes time, careful thought, expertise, advice, and securing buy-in from decision makers and relevant stakeholders. So this is the reality, is that it's a long-term project for most organizations. So proactively taking steps to develop, plan, and implement your organization's EDI strategy, and then implement training in support of that EDI strategy is well worth the effort and will set your organization and your team members up for success. So what can we do and what can we think about doing? First, we have to evaluate how we are currently doing and what we already have in place. You can think about the data collection that Justin spoke about. Second, you can plan out your goals and your strategy and think about what you're able and intend to do. And you can think about your employee and customer-facing EDI policies. You can review your existing policies, as Grace spoke about before, and just really take stock of where you are at. And then think about, be conscious of implementing your EDI initiatives. And to my earlier point, implement training and have a proactive approach to training your team in order to ensure that everyone is set up for success. What's the contrast to taking a proactive approach here? As we move to the next slide, we can see really that there are limitations with a reactive approach to EDI. I go back to the old adage of, by failing to prepare, you are preparing to fail. It certainly rings true here. If we do nothing to prepare ourselves and our organizations, then we're just really not setting ourselves up well here. So, what can sometimes happen is if we haven't taken proactive steps to train or implement policies, then there may be perceived or actual inadequacies in your organization's response to complaints or to issues in your organization. And so that may increase the risk of liability and the potential consequences of or outcomes in any potential litigation. This may arise also as sort of a secondary issue. So, for example, you may have an employee who is, or you may be an employer dealing with a workplace accommodation, and you may be following your workplace accommodation policy and relevant human rights legislation. But the individual that you're accommodating might have undergone a medical procedure relating to their gender identity and is now returning to work. If your team doesn't have the appropriate training and the policies and procedures to help inform them, then they may not be providing all of the appropriate accommodations, for example, beyond those that are medical in nature. So again, just a really great opportunity to take a proactive approach to show that you are complying with your legal obligations and are committed to meeting those obligations, and to ensure that your overall EDI-related goals are being met. And also, an organization is not going to be able to rely on appropriate training and policies for its individuals if you haven't actually implemented that. And that's a great opportunity to be able to show either your stakeholders or customers or an adjudicator that you're taking your obligations seriously if you've proactively trained your team on your policies and expectations. So as we move to the next slide here, again, we have a real compare and contrast going on about the proactive versus reactive approach to training. And I think this applies even more broadly to a proactive versus reactive approach to EDI. So remember, a proactive approach not only requires you to have the strategies, policies, and procedures in place ahead of time, but to also have trained your team on EDI principles, on your organization's goals and expectations, and also on legal considerations. Your best approach is going to be one of continuous learning, reflection, and training. By contrast, if you develop policies and provide training only in response to a complaint or a settlement or an order, then that's really a reactive approach. And while it's still often useful and warranted, and you may in fact do those things after a complaint or some litigation, it doesn't necessarily set you up for to best position yourself in any legal defense that you need to mount or in developing an effective EDI strategy. So if we think about the concepts of prevention and preparedness on one hand, so the proactive approach versus damage control on the other hand, or the reactive approach, I'm confident that we would all prefer to fall within the preventative and preparedness side of the scale here. Other considerations as you decide which approach to take as an organization is the impact to company culture. It's harder to suggest that issues of equity, diversity, and inclusion are important to you as an organization or part of your organization's culture if it's only reactive. And employees and customers and clients and other stakeholders and investors can appreciate the difference. And then finally, a lot of this is really about setting up your management team and your HR folks for success and reducing legal risk on the whole by taking a proactive approach. So think about giving the types of trainings and discussing the EDI concepts that Nicole and Laura have already talked about today. So I'm going to, being mindful of time, and I know we want to get into some cases, I'm going to move pretty quickly through some of this. There is, of course, a legal basis for why we want to do these things and why we need to do these things, why we need to have policies and training, and why it's a great way to demonstrate your commitments to and your compliance with legislation, for example, human rights legislation. In every Canadian jurisdiction, employers have an obligation to provide employees with workplaces that are free of harassment and discrimination on the basis of protected grounds. And we've included on the slide here some of the definitions of harassment that we commonly see. Similarly, in every Canadian jurisdiction, employers are required to investigate complaints as part of their general duty to ensure that workers are not exposed to harassment or discrimination in their workplace. So proactive policies, proactive training in support of these legal obligations goes a very long way to meeting your obligations and providing an adjudicator with evidence of your commitments to complying with those obligations. Here we have on the slide our general duties under occupational health and safety legislation. Under various provincial and federal occupational health and safety regimes, employers have these duties that are up here on the slides. These duties vary from province to province in terms of how prescriptive and onerous they may be. For example, we know in Ontario, there are significant obligations when it comes to workplace harassment and workplace violence policies. But these are generally obligations that employers have and that you'll need to account for. Again, harassment, when we're thinking about it, think broadly and consider broadly when and in what circumstances or obligations to investigate and then address harassment may arise. We've got some examples up on the screen here of where an employer may have responsibility. Sometimes our tendency is to view our obligations quite narrowly. In each case, the context and circumstances will be critical to determining whether you have a responsibility to prevent or respond to harassment or discrimination. And so before dismissing something, do take a proactive approach to something that may at first blush seem to be outside your responsibility. And then consider whether you need to, in fact, conduct an investigation of some kind. And Laura is going to talk to us about investigations. I'll just talk very briefly about the consequences of failing to investigate. Up on the slide here, a lot of different examples of the consequences that may arise in the event that you don't conduct an investigation. Not up on the slide, but and we could spend a great deal of time talking about the other consequences is also, of course, the impact on employee morale, on your workplace culture, on employee retention, and then, of course, sort of, public facing or public relations considerations for your organization and your brand. So I'll turn it to Laura to talk a little bit more about how to go into responding to complaints, and then we'll try to move quickly to some case law for you.
Thanks, Rachel. So let's talk about responding to complaints. So when going to investigate, there are some key preliminary considerations that should come to mind. Ensuring confidentiality. Are there interim protections that should be considered? Could you, if you are the investigator, have you considered your own bias that you're entering in the investigation with? Are you offering the correct support to the complainant, either at the beginning or throughout the process? And should the police be informed? I want to also flag that organizations should be mindful that they cannot solely rely on employees to bring complaints forward. There might be a situation that takes place in the workplace that the employer becomes knowledgeable about, but the employee directly impacted hasn't come forward. That doesn't mean that you don't have an obligation to look into that concern. And also be conscious when reviewing harassment or discrimination complaints that come forward that you may consider are not rising to the threshold of requiring an investigation under your policy. They may involve a series of subtle issues, such as microaggressions, as we've discussed, and it might be difficult for the complainant to fully articulate them in a complaint. So it may be that you at least meet with the complainant to fully understand their complaint. You may, in that setting, learn more information that would give rise to a complaint. Employers under human rights legislation have a duty to inquire. So this is why appropriate training is necessary for executives, HR professionals, managers, so that you are mindful of what you should be looking out for or certain cues. Also, consider your toolkit. Do you have the appropriate contacts to handle these complaints, either internally, or is this something that should be handled externally? Do you have the appropriate contacts externally? Should you suggest crisis counseling, either in conjunction with or after the investigation? And also remember, in circumstances involving competing rights, such as gender expression, sexual orientation on one hand, and religion on the other, for example, one person's code protected ground cannot be used as an excuse to discriminate against others. If we go to the next slide, as an investigator, it's important to remember your limitations. You're not a clinician, you're not a psychologist. And so we have to be mindful of that and go into, again, consider your toolkit. Are you needing to reach out for support in order to handle the complaint, especially if there's an EDI component? And also be mindful of how we conduct ourselves in the interactions in the investigation will also have a direct impact on how that information is received. Okay, if we go to the next slide, we are also mindful that you may not only address complaints with an EDI component from employees directly. Those might also come from customers, clients, patients, and there is a delicate balancing that goes into balancing basically a company's or organization's obligations to its clients, customers, patients, and its employees. So you can't take swift action just because, for example, a customer is involved and they've made a complaint, maybe they posted it to social media, or someone has posted to social media something that's happened in your workplace, as it may have liability resulting for the organization, depending on how you handle it. So, for example, you cannot take swift action and terminate an employee before investigating the complaint and providing them with an opportunity to respond, or liability will follow. And also beware of the EDI components of customer complaints. So, for example, if your organization gets a complaint about a Black employee and they've been called aggressive in the complaint, be aware that there may be racial bias involved in the complaint itself. And then if we go to the next slide, trauma is a key consideration for many of these complaints in this realm, and trauma and being mindful of trauma should inform the investigator of the company's approach to the complaint. So I'll quickly go over some trauma-informed techniques for investigators as I'm mindful of our time. So in the pre-interview stage, participation is a key consideration, ensuring that the investigation meetings are taking place in a private and neutral place, and you can offer the witness a choice of where that might be. When you're beginning the investigation, make sure that you're transparent and you build rapport. Provide a roadmap to the party or the witness to explain how the interview process will proceed and what their expectations are. And then ask trauma-informed questions and close the interview off by saying, I understand that this may have been difficult, leave room for follow-up, and then provide the appropriate resources such as EAP. Okay, we're going to move now over to lessons learned from the case law, and I'll turn it over to Grace.
Thank you so much, Laura. Now, I know we want to get to questions because there's some really good questions in the chat. So we're just going to briefly go over one case, I believe. So can we go to Nelson and Goodberry restaurant? So there's two cases currently that we're aware of in Canada with respect to pronouns and gender identity, specifically in the workplace. They're Nelson and Goodberry restaurant, and then there's Ian and Gallagher as well. That's an Ontario case, and Nelson and Goodberry is a case from British Columbia, all in the last 2 years. So Nelson and Goodberry, a non-binary, gender fluid trans person, worked as a server. They said their correct pronouns are they, them. It was not respected in the workplace. They were dead named, which means using the name that they were assigned to by their parents at birth, and used demeaning nicknames instead. Jesse was terminated after a final conflict between them and their manager. So the tribunal had to deal with this and determine whether this was discrimination, whether the employer's response was reasonable, and was the gender identity a factor in their termination. So if we go to the next slide, on all three counts, the tribunal found that this was discrimination. The employer did not intervene to correct the fellow employee's behavior in order to use the correct pronouns and names. And yes, the termination was clearly a factor, if not the factor, in why Jesse was dismissed from their workplace. So the case law follows this trend in terms of assigning liability both to the employee involved in dead naming as well as to the employer as well, which just speaks to all the concepts we've been discussing. So I'll throw back to Nicole, who's going to moderate a few questions for us.
Perfect. Thank you, Grace. So as Grace said, we got a lot of really great questions. I always find this part to be actually one of the best parts of the presentation, is to hear from all of you on what you're hoping to hear more about. We, of course, won't be able to get through all the questions, but we'll try and at least address a few. So I'm actually going to throw the first one to you, Grace. So we got a question, and the question is, it says, for trans and gender diverse people who do not feel comfortable sharing their pronouns, do you find pronoun policies support these folks? I sometimes worry we add social pressure to disclose. Do you have any guidance to mitigate this?
Yes, that's a very good question. I think that revolves around a lot of the concepts we've been discussing. So in terms of education and advising employees, educating them on the lived experience of gender diverse and trans folk as well. So in terms of having a policy, it wouldn't be some type of mandate. So it's not mandatory or making it a requirement that you share pronouns, you have to share pronouns. That was my intention behind saying, you know, if you feel comfortable openly sharing your pronouns, my name's Grace, my pronouns are she and her. If you know, you don't get a response in terms of these are my pronouns and you are unsure, the best bet is to not gender, to not say him or her, but to let that person in some way declare their identity if they choose. Also recognizing that gender identity is very fluid. It can change. So just because you have one set of this is who this person is in my mind, it might change. So it just revolves all around providing the supports in place to create a safe, comfortable, non-toxic environment. And often you will find, if you have those resource groups, those policies, those trainings on sharing lived experiences, then an employee will feel comfortable to say, you know, these are my pronouns, or these are the pronouns I feel most comfortable with at this time.
Thanks so much, Grace. So we had another good question come in about special programs. So that one, it says, can we ask external candidates information related to EDI, so example, gender, during the application process? So that's a great question. And it's actually a question that we've gotten from a lot of clients that are developing special programs, in the fear that at the recruitment stage, that it could be viewed as discriminatory to ask these types of questions. For example, how do you identify? What race do you identify with? What gender do you identify with? Those sorts of questions could be considered discriminatory. So the short answer is, generally, you cannot ask those types of questions. Usually that would violate human rights legislation. However, there is an exception, and the exception is under special programs. So if you have a special program in place for example, preferential hiring of a certain group of people. So let's say, for example, preferential hiring of Black people because there's an underrepresentation within your organization, then in that situation, it may be perfectly acceptable to ask candidates if they identify as Black. Now, you do have to be careful. Again, this kind of goes back to a lot of the guidance we gave at the outset of this presentation. Whether or not asking candidates for this type of information will depend on your special program, how you've developed it, what you've set out as your eligibility criteria, and again, if it's informed by evidence. Is there actual supporting data that shows that you're actually trying to solve a problem here? You're actually trying to help a disadvantaged group. So I'll leave it there, but the short answer again is yes, you can ask these types of questions in the context of special programs that are properly created. We got another question that came in, and I'm going to see if we can squeeze in two more. There was another question that came in with respect to investigation. So do we need to investigate complaints by former employees?
Why don't I take this one on? So generally speaking, if the complaint raises an allegation of discrimination or harassment, my view is that it is almost always necessary to do so, and it's recommended. So when considering these types of issues, I like to think forward down the road and consider how I will be best positioned to defend against any legal proceeding. And so in my view, it's critical to an organization's defense to be able to say, we received this complaint, we conducted an appropriate investigation, we came to these conclusions, and here are our findings. And the reality is, if the findings are that someone's rights were violated, then we know that and we can address it, and we can be proactive in our approach to fixing any issues that we might have. If the findings are that there were no violations, then again, we can rely on that in our due diligence in conducting an investigation. Just not conducting an investigation at all leaves us, frankly, unprepared and in the dark, and we simply won't know what we're faced with and what we're dealing with in the event that there is litigation over the complaint. So all in all, I think it's always a good approach to do that investigation.
Thanks, Rachel. And let's see if we can get another question in. This one, Laura, I'm going to punt it to you. So does Fasken have anything on canceling culture in the workplace and its impact on EDI?
Thanks, Nicole. So yes, Fasken does have resources on cancel culture that we would be happy to help with. And I think one thing I like to be mindful of with cancel culture is going back to sort of what I was trying to describe about taking swift action or having a big impact in the action taken by the company. It's easy to get caught up in the social pressure of cancel culture, but I think it should all go back to what are your policies, what are your procedures, making sure that you are following them appropriately, considering your toolkit, getting the right counsel, and following the process so that you're not caught up in the pressure of the cancel culture. And we're happy to help, obviously, with any specific situation that comes forward.
Thanks so much, Laura. Just keeping an eye on the time. Maybe we can squeeze in another question. So I'm going to go back to you, Grace, if that's okay. I saw another question that came in for a parental leave policy. What do you recommend around the maternity side of it? In Ontario, under the ESA, there's a specific amount of weeks a woman who has given birth to a child has the right to take. How would you deal with that?
Yeah, so I think it's quite employer and situation specific, because I think there would be a number of business considerations at play. You know, are you small scale organization, or are you larger scale organization? So, in terms of in any way displacing the ESA or doing any top up of that nature, specifically around, you know, we'll call it a parental policy, because I think maternity can be gendered in and of itself, and have some issues with gender inclusive language. So in terms of any type of top-up policy, it's likely quite situation specific, and you would want to look at a number of business considerations. So definitely something that we would be happy to assist with, just with more information.
Great. Well, with that, I think we will probably, I'm not sure we would have enough time to squeeze in another question. I know this is such an interesting topic. I encourage you, if you have any additional questions, or, you know, are interested in speaking about any of the concepts that we've discussed in today's presentation, getting in touch with one of us or your usual Fasken lawyer. So with that, I just want to thank you all for joining us today, and also thank my fellow panelists. As a reminder, please fill in the surveys if you haven't already done so. And I also just want to let everyone know that our next LEHR event will be held on March 30th, and that one is on absenteeism. So please keep an eye out on the invitation for that. We'd love for you to join us for that one as well. And our upcoming event list is always growing. So please visit the Fasken Institute section on our website at fasken.com to register for those events, for any of the events that are of interest to you. So with that, just want to say thank you again, and have a great afternoon.